Hello, my name is Olurotimi Osha. I'm continuing with my discussion on how the state attorney in Montgomery County, Maryland, co-opts the public uh, defender's office that's the Office of the Public Defender to sell out the indigent defendants, and they often sabotage their cases. So, for the so it is said that over 97% of um, the state attorney's office um, cases prosecuted by the Montgomery County Montgomery County end up in convictions, right? Over 97%. The way I found this out was from a private attorney I was trying to hire. And at that time, he had just a few weeks to the case, a week or two. And so he asked for a certain amount. This was um, a long time ago. This was in 2023. By the way, I'm a law-abiding American citizen. I've done videos explaining how I was a victim of a swatting. That swatting was actually engineered and orchestrated by Montgomery County Police Department in order to obstruct justice, and they used fabricated evidence, falsified and perjured statements. So I'm learning about the corruption of the criminal justice system in Montgomery County, Maryland, and that's why I'm doing these videos. That if I'm experiencing this, then it turns out that there must be other people like me who are struggling uh, through an unjust criminal justice system in Montgomery County, Maryland, which targets, pathologizes, and criminalizes certain people, particularly indigent people and black, especially black men. What I want to do now is just uh, explain how the public defender I had, just use my instance, my experience as a case study to shed light on a larger problem in Maryland. Um, as I said, the state attorney's office in Montgomery County is said to get a 90 over at least a 97% conviction rate of cases it prosecutes. The reality is most of the time, the state attorney doesn't go to trial. And, if they go to trial, they'll get over a 99% conviction. So most of the time, it wants to settle its cases through a plea bargain, right? A plea bargain. So that's where the state makes the defendant an offer to maybe not to go to trial in exchange for getting a lighter sentence, right? They get a lighter sentence, but often that they will plead guilty, or they could do, if they're fortunate, they can offer them what's called probation in suspension of judgment, right? So there's no conviction, but they're sort of, there's no conviction. They're saying they're guilty of something, but it's not going on the record, right? It's not going on the record. And if they're able to make it through that time period they're given, then it's immediately expunged from the record. Right, once that time period lapses, it automatically you know leaves the system. There are other deals they can do, maybe, and also is there are these various pleas that they have, which they're not admitting guilt, right? But they're saying, well, if they go to trial, they can't win. That's the defendant. So, is that what it's, is it? It's called an Alfred's plea. I've forgotten what it's called. But the thing is, when one goes takes a plea from the from the state attorney, often it's some kind of indirect admission of guilt. This is not, by the way, I have a Juris Doctor degree from George Washington University Law School, but I'm not licensed to practice law. And this is not legal advice. This is educational purpose. It's not legal advice. So, So in my case, from the beginning, from right away, within a month, right away, I was offered a plea bargain offer, right? The first month, which first of all is unusual. I graduated from law school. I know the state attorney offers you a plea bargain when they file charges and they know they can't win, they can't get a conviction, a trial, but they abuse the process, right, by detaining you, you know, you know, make a make the process lengthy just to frustrate you, right? They harass you. And these things are illegal, but they do it anyway, right? In order to be able to demonstrate that the state is violating your rights, you have to go to court and it costs money. You need an attorney. If you're using a public defender, chances are you don't have money. That's why you have a public defender. You don't have money to pay. You can't afford an attorney of your own. So once you're in the hands of the public defender, they abuse the process. It is unfortunate, however, that the public defender who is has a responsibility, a duty to protect your interests because you're their client, even though the state is paying for them, right? They're under the attorney general, in this case, Maryland's attorney general, who prosecutes cases against right criminal defendants and others, right? Um, so they pay the public defenders, but the public defenders have a professional and moral duty to uh, represent you, right, fully to the best of their ability, right, and not sell you out to the state attorney. But it turns out in practice, because the public defenders, they're human beings, they're ambitious. The public defenders is normally it's normally made up of people who are fresh, young people, fresh out of law school. They don't have experience. And so they are ambitious. They often have the ambition uh, to uh, to be promoted out of the public defender's office and uh, end up being a prosecutor at some point. So they do things. It turns out in practice they do many things that are unethical. Like they cooperate. They call it cooperating, but they're really selling out their clients, right? The defendants, indigent defendants, to the state attorney's office because it's the state attorneys. They're the ones who do the hiring. So if you favor them and help them win cases, and the public defender helps them sabotage their defendants, and then they can put in the good word or get them hired in the state attorney's office as a prosecutor, which is an upgrade, right, from the public defender's office, right? So this is often the case, right? So well, that's attorney misconduct. That's illegal. It can get them disbarred, suspended. They can even get imprisoned. But you take cases are prosecuted, right, based on evidence. And again, you have to go to trial unless there's a Department of Justice official already who's looking at them, who's studying them and gathering evidence. Probably not likely, right? It's not likely unless you're a celebrity, person. But the thing is, the system is so institutionalized. It's so corrupt. It's institutionally corrupt, right? It's an institutional corruption. It's structural, right? It's systemic. It's pervasive. It's entrenched. That the system is corrupt. So there's really nothing that can be done with one person unless they decide to scapegoat some one person, which is probably not likely. So now let me just state, I want to talk in terms of the calendar. I'm going to break this up in several pieces so one can understand the process. How is it when I'm saying, I just don't want to say, well, the public defender's office is corrupt. Um, they sabotage their clients, the public defenders. They've sabotaged me and they've committed attorney misconduct. I just don't want to say that without evidence. So you have to show evidence, right? What happens? And in my case, it's a case of not gathering evidence and allowing evidence to be destroyed and to be obstructed. So I'm going to do this video in terms of the timeline. So I've been represented by the Office of the Public Defender since November uh, November 20 um, November 2023. Prior to that, I had a public defender for my bond hearing, which he lost. That was on June June the 2nd, 2023, when I was wrongfully arrested. So I was wrongfully arrested, and this was my first experience with the criminal justice system. They filed false charges. I've done videos explaining how this happened. So this was in my house. Right now, I'm going to just discuss how there's been this delay, and the public defender has shirked, their responsibility in, not properly filing motions, or filing, filing appropriate briefs, that can move the process forward to getting me exonerated and vindicated, or filing motions to dismiss, or bringing things, to the attention of the court. So the first trial date was scheduled for November 27, 2023. Now, there's something called Hicks Rule in Maryland, right? The Hicks Rule uh, is sort of subordinate. It sort of supports the Sixth Amendment right to a speedy trial. We have a right to a speedy trial under the Sixth Amendment, but it doesn't specifically define or address what is a speedy trial, right? What's a speedy trial? So Maryland um, has sort of delineated what a speedy trial is. And I'm going to do other videos and explain the Hicks Rule. But the Hicks Rule basically says from the time the prosecutor files some kind of information of the arrest, they have 160 days, right, to prosecute the trial unless there's good cause not to do so. Good cause can be, if the client themselves asked for a postponement, you know, or delay, that can be good cause. So the defendant uh, has a right. It's not in the Constitution, but according to Maryland's law, Maryland statute, based on the Hicks Rule, they have a 160 days to get to trial, to have the case go to trial. 160 days from the time they file, whether it's criminal information, they file an arrest, they file charges. 160 days from that time. That's a Hicks Rule. So, but right now I'm just going to focus on how the um, the schedule, right, and how the the uh, the public defender's office has, delayed and allowed evidence to be corroded, degraded, to be lost, right? With this, with the abuse of the schedule, by not filing appropriate motions on time and things like that, not properly representing uh, me as a client, um, and sort of sabotaging my case. So November 2023 was supposed to be trial. The judge does, that doesn't happen, right? I've done other videos talking about the false incompetency to stand trial other orders implemented by Judge James Bonifant as a form of procedural unfairness and to abuse the process, as he was committing fraud on the courts in concert with, they have a state psychologist, it's like they have a racket in Montgomery County. Her name's Dr. Julie Smith. So the objective is they first try and coerce you to volunteer and go and do a mental health evaluation, right? So, and because the plea bargain I was offered, right, was to that they would drop the charges if I go and do that I should plead guilty, right, to a crime I've not committed, that's fabricated, but they won't send me to prison. They won't do anything. They'll give me probation in suspension of judgment, or probation before judgment. So you don't go to trial, just some kind of probation. And what they just want me to do is to go and see a psychiatrist, or a psychologist, do a mental health evaluation, and take whatever treatment they recommend. And I said, no, that's not going to happen. One, I'm not sick. I was never sick. I was never going through a crisis. Ab initio, uh, the reason the police ostensibly came to my apartment was for an emergency valuation petition that was fraudulent. It was fabricated by a man called Jide Wariri. I've done videos discussing that. And my family's since gone to court in Nigeria to demonstrate that one, Jide Wariri is an impersonator, that document, that EP, is a fabrication. I was never given any notice. There was no probable cause. So that's a fabricated document that should be vacated, though it's not a valid document, right? I've never been hospitalized. There was no basis. I didn't have a mental illness. I was not in a crisis. It was part of a swatting, right? So it was part of an engineered swatting, and it's based on false information. And this should not be part of the case. It's actually reason to vacate the all the judgments and to actually dismiss the case because it's fraud upon the court. But in any event, my public defender didn't do that. So November 27, 2023 trial, that didn't occur. The judge schedules to a new trial date. Trial date is was supposed to be March 31st, 2025, right? So over 1 year, right? Over 1 year. I'm going to do something on the Hicks rule later on and just discuss that better. So schedules it to over 1 year, 3/31/2025. That didn't occur. So they're switching public defenders on me. So eventually I get this public defender, graduated from Georgetown Law, had worked in big law, Baker McKenzie. So I'm like impressed. I'm like, okay, hey, at least this person has experience and all that, would not, will be able to beat the other side. So I'm excited that's good. So I'm released from wrongful detention June 25, 2025. So we have a status hearing on July the 3rd, 2025. The public defender didn't show up. She had never contacted me, nothing, right? But she has a case file, right? Because everything from her predecessors. She doesn't show up, right? Again, then another pretrial conference hearing on September 4, 2025. The purpose of the pretrial conference is, to discuss, sort of streamline the case, discuss, outstanding issues. They can discuss, the evidence that exists or the lack thereof, right? So it was an opportunity for my public defender to say, hey, that we don't, to still continue on that, harping on the bill of particulars, that, we haven't received evidence yet of the assault or the crimes this person, the defender, that's me, that I'm supposed to have committed. Because it's the police, right, who came to my home without an arrest warrant, came to my home and assaulted me. And, then they said I assaulted them, right? But they still need evidence for me to be able to defend myself. So they filed charges that shouldn't have been filed in the first place, right? So pre-trial, you can discuss the evidence. You could discuss, the judge, the prosecutor, and the prosecutor. They're there. The defendant doesn't have to show up, but I showed up. I always show up in court. I showed up when I'm not in jail, and they don't prevent me from showing up. But when I'm arrested, when I'm free on bond, and I show up. I'm always on time, so I showed up. She didn't show up. So pre-trial conference, they can discuss the motions. They can discuss motions. It's an opportunity for the defendant to say, well, you know what, these charges are not valid. There's no evidence to be able to prove this case. You can't win this case. The judge can dismiss the charges on pre-trial. There are many different things they could do. They could talk about discovery. They could talk about how discovery is defective. In my case, discovery had been defective, and this was now going on 3 years, right? Over 2 years. We hadn't received the CCTV. We hadn't received body cam that we had requested. Because evidence is critical. That's when you get to trial, it's evidence that you're going to use to prove to the jury, right, that that the client is innocent, and the prosecutor has the burden of proof, of course, and they use evidence as well they have to prove beyond a reasonable doubt that the defendant committed the crimes. So Discovery is the process of discovery is how the defendant, uh, the public defender, the attorney for the defendant can obtain evidence. That's how they can get evidence. They can do a deposition. They can ask, well, if there's conflicting testimony, conflicting statements on record, they can use that opportunity to depose, do a deposition. That's to depose the opposing side's witnesses, right? My public defender didn't do any of that. No depositions, nothing, no motions, no uh, no showing to the judge that, well, discovery is defective, we need more evidence, we haven't been given evidence, there's no bill of particulars, right? You haven't provided us of the bill of particulars. For instance, uh, she eventually assumed that since there was no battery, right, there was no battery in the assault, and it must have been an intent to frighten sort of assault that they were that the cops were talking about, that they were saying, well, that I scared them, because the cops tased me, right? So they must have, so their alibi basically is, well, we tased this person because he was in the process of assaulting us. But the thing is, there were 40 cops with guns pointing guns at me, and I was backing them, raising my hand up, right at my door. So I wasn't, I disabled, they accused me of trying to charge at them with a knife because I'd been falsely imprisoned. That's why there was a knife, because there was a band that locked me in. I didn't know why I was raided. I didn't know why I was locked in, but I disabled a knife inside in a wall, raised my hand in surrender, and then the cops started tasing me, right? So obviously, um, and they were at a distance from me, by over 20, 25 feet, 40 cops pointing guns at me. Why cops? You can imagine how terrifying that scene was. So I'm surrendering, they're tasing me while I'm surrendering, right? Because I don't know why they're there. They never say I'm under arrest. They didn't have an arrest warrant, so they couldn't say I was under arrest. I was alone, so they tased me, right? Um, so intent to frighten is probably the sort of assault that they wanted to use, but there are elements there. And so we have an opportunity to be able to tell the judge that, look, there's no assault. The judge looks at the evidence and the judge can dismiss it, right? That this is an injustice, right? It's an abuse of the process. It's a perversion of justice, and the state attorney should not have filed the charges in the first place. So that hasn't happened, right? That hasn't happened. So in any event, it could even happen because my attorney was not there. The public defender didn't show up at the pre-trial conference, right, where there was the opportunity to raise issues regarding evidence. So there was a motion that was scheduled for September 25, 2025. That was postponed to December 12th, 2025. Eventually, my attorney would call me, my public defender would call me. She had meetings, numerous meetings. I think what was sort of frustrating was she would have meetings about having a meeting to have a meeting. It was bizarre. So, but I thought, okay, this person graduated from Georgetown. They know what they're doing. In fact, I even wrote her a letter to that effect. An email wrote to that effect that, okay, I guess you know what you're doing. That you're confident about the case. So, at some point she contacted me, spoke with me, and told me that, look, um, because we already had evidence that the police had fabricated their statements were false, lots of inconsistent statements. The charge statement says this, somebody else says this. So we saw inconsistencies in the statement. So they're obviously, somebody's lying, right? The police had lied. That's one. Then the police, from the body cam, we also saw that the police had lied, about what happened. That wasn't what happened, right? And the other thing is the EAP that was supposed to have brought them to my home. That's the emergency evaluation petition. My family had gone to court and demonstrated that it was a fabrication, right? And Jide Iwari was an impersonator. And the state of Maryland had actually charged Jide Iwari, right, and Gurma Shumi. So they charged them, they found probable cause. So it discredits them. They didn't dismiss the case with prejudice. They charged them. holding it. So it was obvious that this guy had fabricated an EAP, right? And I'd suffered an injustice, right? So she told me, that's my public defender, that she's going to she said, because these are fabricated evidence, it's inadmissible in court. They were illegally obtained. The police didn't have any arrest warrant to be in my home. She talked to me, and I thought, oh, this person's smart. She said they had no reason to be in my home. They had no lawful purpose, right? And I'm within my rights. There's something called Castle Doctrine in Maryland. So she said she was going to file a motion to suppress all the evidence, so they wouldn't have any evidence. This was what she explained to me. That, and I graduated from law school. She said she's going to file a motion that all the evidence, to suppress all the evidence, right? Because anything evidence obtained would be fruit of the poisonous tree. I've done a video explaining that. So she's filing a motion to suppress the evidence, and if they have no evidence, that it just means the case is going to be dismissed, because police won't be able to, right, prove a case. The case is going to be dismissed. So I'm like, fine, okay, cool. And by the way, I had actually written this myself. I had written a motion as early as November 16, 2023, because I used the time when I was under house arrest to analyze the case myself, researched it and everything. And I looked at the evidence he provided. And I said, look, and I wrote reasons why they should dismiss the case, right? Initially, I was giving it to my public defender, but my public defender said she wanted me to argue it in court. The judge prevented me from doing that. So I'd already made that conclusion as well in one of the pieces of, the pieces of the in one of the arguments that I'd made in that motion to dismiss. So it was funny that it took 2 years for the public defender's office to come around to an analysis I had made 2 years before, right at the beginning of this, of the proceedings. That, okay, this is the situation, right? Uh, they can't win this case. So this was what she told me she was going to do. She was going to file a motion to suppress. So I'm waiting. So I'm like, no problem. I'm waiting. And just a little bit before maybe a week before, just a few days, she does that. Before the motion's done, she told me she's going to file the motion. She'll show me a copy, because I wanted to see it. I wanted that I'd see the motion, you know, see the argument. I wanted to also keep it for my records. And so this was what she let me believe, that she's filing a motion to suppress evidence and to dismiss. She's going to, give me a copy when she's done with the motion. She was still writing it. Then eventually, a few days before the hearing, that's December 12th, 2025, then she, in a meeting again, she says, well, she decided not to, that she analyzed things further, and she saw it didn't apply or something. She decided not to. She didn't explain why. I wasn't going to, but she made an argument that, okay, that she's just going to ask the state attorney to dismiss the case. She's going to try to reach out to the state attorney and say, look, you don't have any evidence, you don't have sufficient evidence, and she's going to just talk with the state attorney. That's what she told me. Okay, I'm fine. I'm not arguing with that. Typically, if this is what she thinks, she's supposed to file a motion. Eventually, she reaches out to me and says, well, the state attorney says, refuse to dismiss the case. So, and that she can't force the state attorney. So she says, okay, let's go, that we'll go to trial. At trial, she's going to do a judgment of acquittal. She's going to argue the case, blah, blah, blah. Argue before the jury at the beginning and after the case. She's going to be arguing that, okay, there's no, that I'm innocent, I'm not guilty. And, these are her reasons. And she's going to, obtain a judgment of acquittal. Okay, fine. Basically, we're going to trial, right? That's what she's saying. 7 days before trial. So the trial was scheduled for February the 9th, 2026. 7 days before trial, I'd given a list of witnesses that I wanted, because when we're going to trial, we still need to present evidence. We have to present evidence to our to the jury. In Montgomery County, according to what she told me, that's a public defender. It favors, it leans towards supporting its law enforcement. It's cops, right? It's very cop friendly. They have a very high um, opinion of their cops, right? So cops would, so that means they would prioritize the testimony of cops because it's cops that are giving testimony, right? So um, 7 days before, so that means in order to be able to controvert the false statements or the testimony of cops before a jury in Montgomery County, you have to present evidence. You just saying your own testimony, they're probably going to they're going to prioritize, they're going to weigh more the testimony of cops over your own claims, right? So obviously we need concrete evidence. It was 7 days before trial. We didn't have evidence. She had not subpoenaed any of the witnesses. I had a long list of witnesses that she was supposed to subpoena, bring to trial to talk. Some, who were witnesses, who were there at the scene, who knew what happened and would discredit the false testimony of the police. Some people who had taken, recorded the scene, what happened, to demonstrate that I was a victim of an orchestrated police assault and a swatting, right? But she contacted none of these people. She hadn't contacted anybody. She hadn't subpoenaed anybody. So that was a problem, right? That was a problem. Um, so 7 days before, no evidence, no subpoenas, no depositions, right? She didn't depose anybody in order to address, the contradictory statements of the cops, right? No deposition whatsoever, no preparation. 7 days before trial. So obviously, I'm finding that okay, this person is basically walking me into a conviction, but she's saying no, no, no. You can't be convicted. You can't be convicted. How about if I get to trial and the police, they continue with their lies, even though they don't have evidence. But you haven't, the my public defender hasn't obtained concrete evidence that can contradict uh, the false statements of the police. She hasn't brought anything. She's just going to use oral testimony, my testimony, the police, the whole incident, the whole all the charges. The objective was to discredit me, right? It was for a smear campaign, right? And they don't know me, So I'm going to stop this video here and I'm going to continue. My name is Oluro Timosha and I'll keep you posted.